Yes, sir.
You gotta get the firm right?
Yes, sir.
Okay.
Absolutely. May it please the court. Good morning. I'm Anthony Russo. I represent Mr. Carl Whitman in this motor vehicle accident case. Also represent State Farm, who was added to the judgment under the non-joinder rule after the trial. State Farm does not have any of its own issues. This is Mr. Whitman's appeal issues. The trial court here made a series.
Set the scene for me on the what I'll call the discounting of medical expenses.
Yes.
Am I clear that that is only as it relates to future meds?
Past and future are at issue. Collateral source rule applies to past only. Colomar and Jackalone from this court establish that market pricing is relevant in evidence as to both past and future.
Okay, thank you.
You're welcome. The trial court here made a series of related evidentiary rulings, one before trial, several at trial, that were increasingly prejudicial to my client. They blocked us from presenting any evidence as to what medical care providers in the community and the medical care providers at issue in this case, which are Moreno Joseph Spine and Scoliosis Center and Dr. Epperson, who works there, would accept and would expect to be paid as full payment for their bills, not the list price that they testified to at trial. The two particular procedures at issue in this case were epidural steroid injections, which Dr. Epperson said for a series of 3 per year would cost approximately $10,500, and a radio frequency ablation test, which would cost $16,000 per year. This is for the rest of the man's life. Those were their list prices and what would be charged. We knew that going in. We admitted that our negligence caused the accident. We knew these prices, so we would be testified to. So we prepared our case in advance, ready to present a letter of protection that Moreno Joseph Spine was operating under to show bias on the part of and financial interest.
Did you have a pretrial ruling on that?
Yes, there were 2 motions in limine, Your Honor. One at record 205 and one at record 270. The one at record 205 from the plaintiff said, hey, we want no evidence of health care insurance. The second motion went to Dr. Shim, and Dr. Shim, who was our CME expert, was ready to testify that the charges of Moreno Joseph Spine are typical in the community, but they'll negotiate off that list price. The second motion in limine said
They will, or any medical provider will?
both.
Okay.
Dr. Shim was ready to testify as to both. He established in his proffer that he knew from his professional work what providers in the community would do, and he knew from looking at Moreno Joseph Spine what they would accept off the list price. We also had Christina McCord, who was the former accounts receivable representative at Moreno Joseph Spine at or near the time Mr. Furvister received treatment there, who would testify that that outfit, Moreno Joseph Spine, would accept $1,600 as full payment for that series of 3 epidural steroid injections, not the $10,500 list price.
Was the jury verdict itemized as to future medicals beyond the fact that this is future medicals and a lump sum amount?
No, it was a lump sum amount.
And did that,
as to futures.
Did that correlate to the amount requested, or was it less than the amount requested in closing argument?
As I recall, I believe Ms. Zervos, who was the trial lawyer, said if you add up what Dr. Epperson testified to, it's between $200,000 and $400,000. Okay. Give him 3, and I think she said 300, and I'd have to defer to the record, but I think she said 300, suggesting that to the jury. The jury came back at 340.
And the evidence excluded would have, if believed by the jury, came back with a jury verdict even less than the amount given.
Far less. In our post-trial motions, we assembled jury verdicts with the similar injuries and similar treatments around the state of Florida, and came up with $52,000 as being the typical award in this case. And that analysis...
We don't know from that whether those numbers were based on a discount off the rack rate.
I would have to go back and look at the analysis, the spreadsheet analysis that was done with the post-trial motions, Your Honor, to tell you that. I don't know.
Okay.
But we know that this award was far outside by a factor of 6. There's some evidence in this file that it was outside by a factor of 6 what is typically awarded for these types of future medical care. And to set the scene further for you, Judge Valenti,
you moved for remitter and it was denied.
Yes, we moved for remitter.
The same argument was made as to the rationale.
Yes, it's reasonably certain to be under the remitter statute. In this court's case, de Grandchamp, the expenses awarded have to be reasonably certain to be incurred. Mr. Furster's never going to pay $10,000 for a series of 3 epidural steroid injections from Moreno-Joseph's spine in the future, because he's going to go into that office with cash, and he's going to be a cash-paying client. He's never going to pay $10,000. He's going to pay the cash price. And we know what the cash price is. We just didn't get to talk to the jury about it because the judge shut our mouth as to that evidence, and we didn't get it in. And that's why we have an inflated verdict.
What was the exact rationale why the judge changed his mind during trial?
What happened, the 2 motions in limine went to a hearing before trial, 1 week before trial. The transcript's at record 1514. And I think the judge got confused about the collateral source rule, thinking that evidence of what would be accepted in the market was collateral source rule evidence. He did the error at the ruling before trial is at record 1537, and he makes 2 rulings. He says at that page, "I'm ready to rule," after he hears the argument of counsel. He says, "On the pass meds plaintiff, you can board the full amount. We'll do the collateral source set-offs afterwards." Usual, typical, that's fine. He says, "But as to Dr. Shim," that's the second motion in limine, he divides his ruling. Says, "That line of inquiry, grant the motion as to the past bills." That was wrong. He says, "I think that the defense can ask that," meaning what the market accepts, "to future billing without getting into specific insurance, private Medicare, etc., but the doctor may be willing to accept or negotiate." Ms. Zervos, the plaintiff's lawyer, asks for some clarification at the next page, and the judge expands his explanation and says, "What they're willing to accept. You're billing $60,000 for this procedure. Does every single patient pay that? Do you negotiate off of that sometimes? Are you willing to accept less?" Those types of questions. So those types of questions are okay. Great. We're a week out of trial. We've got a letter of protection. We've got Dr. Shim and we've got Ms. McCord ready to go and we're going to ask them, "Hey, do all your patients pay that? Or do they negotiate off that sometimes? Do they accept less?" We're ready.
Let me ask you, separate past from future. To do that with respect to future meds, tell me why that just doesn't involve a whole lot of speculation. This guy may get insurance, he may change insurance, he may go on Medicare. I mean, how can I figure out what the discount off the rack rate is going to be in 20, 30 years?
Well, what we're trying to establish is today, what is the reasonable value of those expenses? And there are other instructions, as you know, Judge, as to how to discount futures, and you can either do it evidentiary-wise or give it over to the jury. But the task that was at hand for this jury and on this day at this trial was to establish what is the reasonable value of certain of the medical expenses that are reasonably certain to be incurred. So what is the market value of that epidural steroid injection? And the case Colomar that we cite, the federal case that was adopted by this court in the Jacalone case, says differential pricing, says what the market charges for similar services is one relevant measure of the reasonableness of those charges. And what it goes on to identify differential prices and pricing. In addition to a market analysis, the case law reveals that the price charged for the same services to other patients is also relevant to the question of reasonableness. So we don't want to talk about what Aetna and what Humana charge or discount or those sort of contractual discounts. That's not what we're after. We want to know, hey, Mr. Treatment Provider, what do you accept? We know you charge $10 for an aspirin, Tampa General, but what do you accept? We don't.
But what he accepts may be all over the map, depending on who he's dealing with as the third-party payor.
And that makes it a jury determination. That doesn't mean it's not admissible. Dr. Shim says, I know that that treating physicians, in his proffer, he says, will take between 25 to 40% off their list price. And I know that in this community, well, he says, my cash charge for doing epidural steroid injections is $500 per injection. So we have this evidence of what the value of that service is, and we actually know what Moreno-Joseph Spine charges cash-paying patients. I mean, that's not speculative at all. We know it from Ms. McCord's testimony, but she was not allowed to testify as to what the actual cost would be. I mean, that's direct evidence relevant to the hot issue in the case. What's the value of these expenses this man will incur in the future?
Was a special jury instruction asked to clarify, to instruct the jury on the patient's obligation is not to pay whatever the provider demands, but to pay a reasonable amount? Was there any consideration given to that, or?
Let me explain how that works, Your Honor. The general negligence instruction just says reasonable for motor vehicle cases.
But if you've got an instruction dealing with reasonableness of medical bills of some sort.
In PIP cases, Your Honor, there are instructions that we argued to the trial judge in our memorandum in opposition to their motions in limine. And we cited them. They're jury instruction 413.4. And in those cases, the jurors are instructed that a reasonable charge, in deciding whether amount of charge is reasonable, you may consider evidence of usual and customary charges and payments accepted by the provider involved in the dispute, reimbursement levels in the community, and some other things.
So that was your authority for asking for your in limine motion. And you never got that instruction because you never got to put on the evidence to say it wasn't reasonable.
Well, that's a PIP instruction. So
Well, I'm trying to find out in this case, were any instructions given on using the term reasonable?
Well, the judge made some further rulings as we got further into the case, and he kept I think I can answer that by...
You said you were hobbled at every turn on this case.
Yes, because after we got the trial, now we go into the trial with this unequivocal ruling. You can ask these questions, says the judge. Do all your patients pay that? Do you negotiate?
I'll give you 5 minutes, so you may want to...
Yes, sir.
I won't ask any more questions.
Okay. And then we get to trial. The first day of trial, Ms. Zervos puts Mr. Fursar on the stand. He establishes I paid $40,000, $50,000 in past meds. And then she moves Ori Tennis. She shifts the burden to us by doing that. She moves Ori Tennis at record 3543, saying, I don't want them, Judge, to talk about what Moreno-Joseph Spine accepted in the past, and I don't want them saying what he would accept on negotiated letters of protection. Well, the judge hears argument on that. Ms. Barnett, the trial lawyer, says we're not looking to put in collateral source rule evidence, and the judge changes his mind at page 3553. And he says, okay, I think that I'm going to change my mind on allowing the question, willing to accept. I think that's not a proper question. It's too confusing to the jury what someone may accept, and because there's all different kinds of insurance companies. So the judge has just done a 180. He gave an unequivocal ruling. We'd had no reason to expect it would be subject to change, and now we cannot ask the questions that he said 1 week ago we could ask, and we're 2 days into trial. And we didn't want to put on any evidence of what different insurance companies wanted to accept. We had Dr. Shim who was going to say, I know what people accept in the community, I know what I charge, I know what they charge. None of that could come in because of what the judge did. All we could do was proffer. And then we made proffers with Dr. Epperson. At page 3679, Dr. Epperson didn't know anything about his charges. And that meant that we needed to put on our own person, who was Miss McCord, because she knew what Moreno Joseph Spine charged in reality. We put on Dr. Shim, and in 3 pages, it wasn't a big deal. At page 4050, Miss Barnett was able to establish, through Dr. Shim's proffer, that various entities will negotiate off their list price, that they're willing to take 25 to 40 cents on the dollar off their inflated list price, and that his cash list price was $500.
You're right, you're 5. You want to keep going, or you want to save them?
I'll finish.
Okay.
Just so the court is clear. And the judge said, I won't allow it. He says at page 4058, after hearing Dr. Shim give this testimony, I have no doubt that what Dr. Shim is testifying to is true, all true. However, where the case law has developed to date, in my opinion, the only relevant inquiry is the question, are these bills reasonable and customary in this area? That's it. I don't think that under our law we can get into negotiations and what other entities provide or what cash discounts are anywhere. I know these rulings are discretionary typically, but these are legal errors. This is contradictory to Jackalone. It's contrary to the Hassan case out of the 4th DCA, which says these list prices are not reasonable prices. We needed a defense. We didn't get it. And we got slammed in closing argument when Ms. Zervos got up and said, and as far as the cost of medical care, you know what? We're all victims to that. The cost of medical care is the cost of medical care. We have no control over that. We're going to leave them out there? Mr. Wickman isn't going to come negotiate those costs. Well, that's not really true. And we had evidence to say otherwise, and the jury gave him $340,000 in future meds that he's never going to pay. That's why it's unfair, and we need a new trial. Thank you.
All right, I'll save you 3 minutes.
Thank you.
Good morning. May it please the court. My name is Tracy Carlin, and I represent Mr. Forrester. And Mr. Forrester, of course, is asking this court to affirm because, of course, every issue that we're looking at today is an abuse of discretion standard. And I just don't think you can say no reasonable trial judge would have done what this trial judge did under these circumstances.
Well, he just pointed out in closing argument the judge's ruling was used to your advantage, not you per se, but your client's advantage.
Well, number one, I'd say that issue is not preserved because it was not objected to. Number two, I would say that was not an inappropriate statement. Just like one of your honors asked, wouldn't it be speculative to say whether he would get those same discounts in the future versus what he got in the past?
But isn't all future everything always going to be speculative?
To a certain degree, but to go back to your question, yes, there were instructions given regarding both the reasonableness of the cost. If you look at the standard instruction 501.2b, it says the reasonable value or expense of medical care and treatment necessarily or reasonably obtained by the claimant in the past or to be so obtained in the future. So there was an instruction given to the jury about reasonableness.
I guess my question is, doing role reversal, if you get an instruction on reasonableness, but you're not able to put on evidence as to what is reasonable or not reasonable, what's the point of the instruction? You might as well just get a directed verdict as to future medicals.
Well, Your Honor, I think that the problem is that they're saying that the Jackalone case out of this court, Gulf Surgery, Colomar, Columbia, they're all saying that those cases support their argument. But each and every one of those cases are discovery cases, saying that, yes, it's discoverable what these contractual discounts are, but they also put it in the context of the other factors. One factor being the fair market value of the service. What do other providers charge for the same services in the community? That's one factor. The other factor is potentially contractual discounts. The third factor, which puts the contractual discounts into context, is the internal cost structure of the provider. And that gets to the question that you're asking earlier, Judge LaRose, which is, how do we pick a number? How would the jury have a context in which to pick which one of these contractual discounts they should choose? Because If you recall from the proffered testimony, you have Ms. McCord saying, well, we try and get 100% from automobile people, but if we can only get 45 to 50%, we're happy, but we try and get 80% under this context, and if it's an out-of-network provider, we get 100%.
I've got a doctor who's going to testify that as a general proposition, a provider will give a discount of 25 to 40%.
But how does the jury choose what's the percentage without looking at why is that percentage there? The only reason there's a contractual discount of any kind, with the exception of maybe this cash price thing, which I'll address, is because there are insurance contracts. And this court in Fernandez expressly said, we hold that evidence of these contractual discounts standing alone is insufficient to show that these charges are unreasonable. And the reason for that is because you need to look at the internal cost structure. If I'm a doctor and I provide certain services and I contract with Blue Cross Blue Shield, I might be willing to take a bigger haircut, a bigger percentage cut, because they have 1,000 gazillion patients. They're going to bring in so many of them that are going to have X procedure, and I know I can make up my profit margin from that. But if I'm talking about some small insurance carrier that's only going to give me 1 or 2 patients a year, I'm going to not take as large a discount.
But what I'm struggling with is the rack rate is a fiction. Nobody pays a rack rate for health care, airplane fares, hotel fares. So not allowing them to go into that area basically results in them paying an inflated damage amount.
No, it's not that.
Tell me why.
Okay, why is because in order to place that not rack rate into context, you have to do something besides just pick strange percentages out of the air. You have to put it in the context of the cost structure, the internal cost structure. Both Colomar and Columbia both talk about that. And the reason is because in both of those cases, there was some inference that the hospital or the provider was providing a different price to people in litigation versus the people who were not in litigation. So there was a basis for that differential pricing that was not necessarily market driven. But so in this case, to just simply throw in, without putting in the cost structure and why the prices or the discounts were created the way they were, you can't put that in context, so the jury is just speculating.
That wasn't the basis for the objection, though, was it?
What?
What you just said.
Well, it was partly that basis. I mean, the reason...
Was that argued to the judge in the middle of the trial, or was that argued at the motion in limine?
Well, I think, the argument made at the motion in limine was this is just unfair. There's no context in which to place this. Then at trial...
And were you precluded from not you per se, but your trial counsel precluded from putting in context?
No, but it's not...
You could have put on other evidence if you wanted to rebut their claim of an inflated price.
Theoretically, but I mean, I think the problem is that what they were asking to do flies in the face of how you establish damages, and also the Supreme Court precedents dealing with collateral source evidence. And clearly, they want to say, well, this isn't collateral source evidence because we're just talking about contractual discounts. Well, contractual discounts...
Can you help me?
Sure.
Past medical, what were they covered by?
They were covered by both PIP, which, bills at a certain percentage up to a point, and then they had automobile insurance.
Private
health insurance.
Yeah, private health insurance, which then, of course, is not a collateral source.
No, they are collateral sources, and they received $46,000 in set-offs as a result. So the issue is that let me go back a second too, because the question was, are past medicals at issue in this case? And no, they aren't. At trial, the appellant conceded at trial that they didn't want to use this evidence for past medical. And if you look at pages 15, 25 through 29 at the motion in limine hearing, they say, we concede as to past medicals, those guys get to board the full amount of their past medicals, and then you give the collateral source set-offs after the fact. And that's what in fact happened. They received well over $46,000 in set-offs. So we know there were some contractual discounts, there were some monies paid by insurance that were set off against after the trial. So to then say, well, but we can now get into that kind of evidence as to future medicals flies in the face of Supreme Court precedent that says collateral sources and collateral source benefits cannot be considered for purposes of future medicals. And that's Rollins and Pizzarelli and Sheffield and Meesom, all the cases we cited in our brief. The reason is the very speculative concern that the court had in the beginning, which is, how do we know Mr. Forrester isn't going to have insurance in the future? They're saying, oh, he's going to walk in the door with cash. Well, that's not necessarily true. Why would he, if he has insurance that he's paid for or he earns through his insurer, why would he go in and then try and negotiate a cash price he has to pay out of pocket when he's been paying premiums for his insurance all this time? So it doesn't make sense, and the cases just simply do not support what they're saying. And in fact, I think the reason the trial court changed his mind in the middle of the trial is because he started thinking about it and said, wait a minute, this is like if I ran a garage, if I repaired somebody's bumper, I might charge them $500. But then after I do the work, if they show up and they say I only have $100, so it's $100 or nothing, I'll take $100. Or I might do it for free because he's my friend, or I might give him some other discount because I have a coupon. But that doesn't mean my $500 charge is unfair.
That doesn't undermine the potential that $500 is reasonable.
That's exactly right. And that's what the court considered.
And there are a number of reasons why I might take a discount off what I'll say is presumptively a reasonable price.
Right, exactly. And so by just throwing percentages out there, there's no way to put a context on it and explain why, for Mr. Forrester, he got these discounts. And the other reason that it's important in this case is in each of the discovery cases they rely on, the charges were actually tied, or the percentage discounts were actually tied to the actual services that that person received. In this case, they didn't want to talk about, with the exception of epidural steroid injections and the cash price for that, they didn't want to talk about what services Mr. Forrester received and what discounts may be applied to those specific services. In other words, they never got any evidence on proffer about discounted rates for the RFA procedure, the $16,000 procedure that includes a lot of other stuff than just an RFA. And then they never got that on the office visit, so for the jury to come with the number that they came with, it was an appropriate number. To answer that question, they came up with $408,000 apparently and reduced it to present value in accordance with the present value instruction. That's how they got to $340, or at least that's what I have to assume. With respect to the letter of protection, I don't think that there was any change of ruling from pretrial to mid-trial. Let me back up 1 second. On the reimbursement rate thing, we have moved to strike a portion of the reply brief dealing with that reimbursement rate because for the very first time in the reply brief, the appellants raised a constitutional argument that hadn't been previously raised. So we're just asking the court to not address the constitutional argument.
Get a lot of motions in this case.
Pardon?
Got a lot of motions.
There were a number of motions in this case, Your Honor, I agree. With respect to the letter of protection, I don't think there was a mid-trial change of ruling. I don't recall that, and so I can't say 100% that that's not true. But what I do recall and what I can tell you is at one point during the argument, trial counsel for Mr. Forrester said, wait a minute, Your Honor, I didn't think we were going to talk about this letter of protection because pre-trial counsel had agreed that since it wasn't signed, we were going to talk about it. But if we're going to talk about it, here's why it doesn't apply, and the court excluded it. The reason it doesn't apply is because at no point were Dr. Epperson's office, Moreno Joseph, relying on that letter of protection for payment. They billed PIP and automobile insurance, so they didn't have a big outstanding balance. And of course, most defendants want to use a letter of protection saying, hey, they're biased because they have $32,000 or 32,000 reasons to tell you that he's really injured when he's not, because they're getting their money out of the outcome of the case, so therefore they have some financial stake in the claim. That wasn't going to happen here. The letter of protection may have been there, it was in the record, but it wasn't relied on for payment because they'd been paid, and we know that from the $46,000 in collateral source setoffs. In addition, and of course in the answer brief, or in the reply brief, the appellant argues, well, wait a minute, the only evidence in the record that the letter of protection wasn't relied on for payment was a statement by counsel, and a statement by counsel is an evidence. But there was no attempt to refute it in the record. Trial counsel for Wickman and for State Farm never said, wait a minute, that's not true. They are relying on the letter of protection. And again, we have the $46,000 in set-offs to know that that was in fact the case. In addition, although this court has seemed to issue an opinion saying, well, yeah, letters of protection that where there's a financial stake in the outcome of the case, that establishes bias. That has now been changed, at least under Katzmann, which is how this whole letter of protection thing got started. The 4th District has now limited that opinion and said in Ranjana, it's not because they're a hybrid expert, it's not because they're a treater, and then now they're testifying as an expert that we think there's an issue. It's not because there's a letter of protection, because all they're trying to do is get paid ultimately. It's because of the referral relationship between the lawyer and the doctor. And by taking referrals from lawyers, the doctor is injecting himself into the litigation, and that's where the bias comes from. In this case, it's clear from the record that Mr. Forrester went to see Dr. Williams all by himself because his wife and he had been treated in that practice before. Dr. Williams referred Mr. Forrester to Moreno Joseph. He saw Dr. Joseph there. Dr. Joseph referred him to Dr. Epperson. The lawyer didn't have anything to do with it. And so because the letter of protection wasn't part of the record or wasn't relied on for payment, and because there's no referral relationship, we think it was irrelevant. The trial court did the right thing to keep it out.
Is that the reason why the judge kept it out? Specifically address those points, or that's your argument as?
Well, that was our argument below, and that's our argument here, that he's not relying on it for payment, and it would be misleading to the court.
That was a finding of fact that the judge physically made.
I don't know that he
applied
ever
in this
made
case.
a finding of fact. He just
As opposed to it would confuse the jury or as a
Yes.
collateral issue. Is that, well, which is it? The
Well,
judge said
it was that he didn't believe, I don't think, he didn't exactly say why he excluded it exactly. He just said, hey, I'm not going to allow it, but then he went ahead and allowed them to explore Dr. Epperson's bias on other levels. And so that's another reason why the error in this case is harmless. He said, well, I'm going to let him ask about what percentage of income they get from litigation patients. I'm going to ask him about what percentage of revenue they get from motor vehicle accidents. And so he gave him some way to attack his bias, but I think he accepted the argument made by trial counsel for Forrester that because they weren't relying on it for payment, there was no financial stake in the outcome of the litigation, and therefore there's no bias to pursue. And so he kept the letter of protection out.
They were not relying on the letter of protection at the time it was given. They ended up getting paid, but at the time the letter was given, what was the purpose of the letter of protection is what I'm asking.
Well, apparently, according to trial counsel, our trial counsel, they had an internal policy that any patient who came in and reported a history of motor vehicle accident had to sign a letter of protection without regard to whether they had insurance or didn't have insurance. So they just did it in case, I guess, ultimately insurance didn't pay. But in this case, he walked in with PIP and health insurance. And so therefore, and I know we had that dispute about whether counsel's statements are evidence or not, but they want to rely on counsel's statement to say this is the internal policy, so we're relying on counsel's statement to say they're not relying on it for payment. But in the end, no one ever disputed those facts below. But on the final issue, which is the remitter, I do think I need to point out that from our perspective, that issue was totally unpreserved. The whole basis of the remitter argument is that the evidence was insufficient to support the amount of damages that the jury awarded on future medicals. Sufficiency of the evidence can only be preserved if a party makes a motion for directed verdict either at the close of the plaintiff's case or at the close of all the evidence, and they never did. And they never made objections to any closing argument that our counsel gave regarding what Dr. Epperson said, here's $3 or $4 for this, or $3,000 for that and $16,000 for that. They never stood up and said, whoa, the evidence doesn't support that claim. So they didn't preserve it, and so therefore the trial court really had no alternative but to deny the motion for remitter. But even if it is preserved, I think when you look at the record at page 3679, Dr. Epperson clearly stated that to a reasonable degree of medical certainty, this man will need future medical care. Then he said, and to a reasonable degree of medical certainty, he's going to need no more than 3 epidural steroid injections for pain at $3,000 each. He's going to need 1 annual RFA, and he's going to need 3 or 4 office visits per year at $125. So he gave him a menu. And that's not only in his testimony at trial, which of course, he's a talker. he talked along for a while, and he'd say, well, probably every now and then, and likely every now and then. But when you look at Plaintiff's Exhibit 4, which is the medical records from Moreno Joseph, his May 2nd chart note lists the menu. It says, you know, he's going to need an RFA annually at $16,000. He's going to have up to 3 epidural steroid injections on a yearly basis at $3,000. He's going to have 3 to 4 times a year appointments with doctors for medication management at $125 per visit. The jury had this. So they could not only rely on his testimony at trial, but they could rely on the menu that he provided them. So the evidence is sufficient to put the range, and he had a mortality rate, 16.48 years, 16 times the number, they got to 408, and they came up with 340 reduced to present value. So from our perspective, the court just needs to affirm this case, and we would request that you do so.
All right.
So unless there's other questions, I'll hang up.
Thank you.
Thanks.
Mr. Russo, you do have 3 minutes left.
Thank you, Judge. The jury awarded $51,000. Health insurance paid $46,000. The final judgment shows the deduction. There was $5,000 not covered by health insurance. The letter of protection applies to that $5,000. Number one. Discretionary versus legal error. Yes, I agree that evidentiary rulings are typically discretionary, but I think we've demonstrated that the judge had a misconception about what kind of evidence was admissible and what the state of the law was, and this court should look at those rulings de novo. This court in Jacqueline versus Helen Ellis said that services rendered, and it was a discovery case, said that the discounts granted to various categories of patients that it serves, including self-pay patients, is critical, agreed that it was not only relevant but critical to establish the defenses to the reasonableness of medical charges. And these discovery cases were transformed by, in the Fisher case, were applied to motor vehicle accident cases. So Colomar, Jacqueline are discovery hospital cases. They now, that line of law now has been applied by this court to motor vehicle cases. So these are not contractual discounts that we're talking about that are prohibited collateral source evidence. These are market value evidence that is permitted under Colomar and Jacqueline. And I do know that the Fernandez case, where then Attorney Judge Northcutt tried to show that contractual discounts meant that Tampa General couldn't put a lien on his recovery for his client. And this court said, without more, that contractual discount is not enough. But here we have more. We had the letter of protection to show bias. We had Moreno Joseph's fines cash price through testimony that never got in. The letter of protection never got in. We had Dr. Shim's cash price, which never got in. And we had charges reasonable in the community, which never got in. So the jury never heard all of that evidence. And as to the remitter, court should be careful. As to the reasonableness there's 2 questions. The remitter statute under the Grand Champ says, is this person reasonably certain to incur the medical expenses? It's reasonably certain. That's the Grand Champ. But as to whether they will need the future care, is the care reasonably necessary? So there's 2 separate...
Down to less than a minute to wrap up.
And so we asked that there be a reversal and a new trial. I would end with saying we can't be castigated now for not putting on different evidence. We went into the trial knowing we could ask certain questions. We prepared our case with that evidence in mind. No hint that ruling was going to be flip-flopped on the 2nd day of trial. It was. We were surprised we didn't have a chance to get on our feet. Please reverse. Thank you.
All right.